Good evening. Hi, I'm so excited to see everyone. I'm Jennifer Acey, the Mayor of Bernards Township, and we are very excited that you all came to learn more about the updated information on the very important topic of affordable housing. So I am joined here by many of the Township Committee. So thank you to our Deputy Mayor, Janice Fields, for being here, as well as Committeewoman Anna McCarthy and Committeeman Andrew McNally. So thank you all for being here. And I do believe that one of our Assemblywomen will be coming here very soon. So I believe Assemblywoman Nancy Munoz will be arriving. So this program is really for you all. As you may know, we tried to put the information out as quickly as we had it, that there's a new law in town. We need to understand what it is. So to try to ensure, our Assemblywoman Nancy Munoz, we just mentioned your name. Thank you so much for coming. This is a very important topic, and there is a new law, and prior to the new law being signed in March, we were able to secure what we feel is one of the best planners that we could have to help us navigate this throughout the next year. So Kendra Lely has deep expertise, and I feel completely confident in her ability to help us along with our professionals as we look forward to helping to ensure that we retain the important character of Bernards Township at the same time to be able to fulfill what the Trenton mandated requirements will be related to affordable housing. And as we all have said, none of us are against the concept of affordable housing. We really believe that, having that opportunity is important. The issue is the overdevelopment that comes with, since no municipality has the ability to actually construct these units, so therefore we have to rely on developers, and unfortunately, that's where we have overdevelopment and how that can affect our community. So Kendra will be presenting for us, and then towards the end, there'll be an opportunity for Q&A. So this is going to be recorded, so feel free to take notes, but it will be recorded and posted on our website, as well as the slides. And when we get to the Q&A session, if we can just remember that we'll need to repeat the question so we can make sure that it's recorded. That way, when people hear it back, they know exactly what the question is. So with that, with no further ado, we'll go ahead and invite Kendra. Thank you for putting this together.
Thank you, Mayor, for those kind words. I hope I can live up to the reputation that precedes me. My name is Kendra Lely. I am a professional planner in the state of New Jersey. My background is that I am a New Jersey girl. I went to Rutgers both for my undergraduate and my graduate degree. My undergraduate degree is environmental planning and design. My graduate degree is Masters of City and Regional Planning. I have done most of my practice in New Jersey. I've been doing this for close to 34 years now, and most of the work that I do, I would say in the last 15 years, 50 to 60 to 70% of it is affordable housing. I represent municipalities mostly. We do my firm is Kyle McManus Associates. I'm with them. Beth McManus and Jim Kyle are the principals of that particular firm. We all do municipal work. There's a little bit of developer work that we do. Any developer work that we do typically is 100% affordable housing, so we don't necessarily represent developers all the time. But most of our work is municipally based, and then myself, Jim, and Beth, that are part of our firm, we are all what's known as special adjudicators or special masters for court systems throughout the state of New Jersey. So we have a role of not only preparing plans for municipalities to be compliant with the law, but also reviewing plans in the previous round and the third round, although we're still in it, for municipalities to ensure that the plans that the municipalities submit to the court are also compliant, and we help negotiate that amongst the municipality as well as any intervener which would be a developer or Fair Share Housing Center, and we'll talk a bit about that. So that's a bit about me. I think tonight really what I'd like to talk about is kind of the past, what has happened in the past, briefly talk about the history of affordable housing, not only in the state of New Jersey, but also here in the township. Presently, what do the statistics look like? How are you all doing as far as meeting your plan that you had approved? And then future, really talking about the fourth round, what the new Fair Housing Act says, and kind of what the next steps would be, as we start to put a planning strategy together to meet that obligation. So why do towns need to provide to provide a realistic opportunity for affordable housing? The mayor had hit the nail on the head. You as a municipality, most municipalities are not going to actually build affordable housing. You're going to provide what's known as a realistic opportunity for affordable housing. And that comes from the Mount Laurel I decision back in the 1970s, which basically said every municipality has a constitutional obligation to provide for affordable housing. And that constitutional obligation is what created the need for creating zoning to allow for that realistic opportunity. I think the other part of it is need. We all know that affordable housing is scarce in New Jersey, especially in New Jersey, and many states throughout the nation are actually struggling with this currently. The need for affordable housing in New Jersey is, as of I think last year, the beginning of this year, was about 200,000 units of affordable housing is the need. And so we know that it's out there. You all probably have family members that have looked at housing in New Jersey and kind of just shook their head and figured that they probably couldn't afford it ever in New Jersey. So there is a need, and we know that. But so how does a town meet this constitutional obligation? It is through what's known as a fair share plan. The municipality will put together, it's part of your master plan, it's a housing element and fair share plan. This fair share plan is if you can imagine, it's a mapping of how you're going to put together enough units to meet your constitutional obligation, which is a number. That number comes from it comes from lots of different places, but it will be given to the municipality now through the Department of Community Affairs, which is a state agency. So the way that you do that, majority of ways that you meet that obligation is through two. One is inclusionary zoning, and one is through municipally sponsored programs. Inclusionary zoning is what most of you look at when you think of a developer proposal. 80% or 85% will be market units, 20 to 15% will be affordable housing units. That's inclusionary zoning. That means that you have zoned for the opportunity for a builder to come in or a developer to come in, create the opportunity for affordable housing through that particular development. And inclusionary zoning works because it's what's known as upzoning. You take, let's say, a density that's pretty low, you allow for that to increase in order for that developer to provide more market rate units to subsidize the affordable units, because people can't build affordable housing without any kind of subsidy to help provide that affordable housing. The second way is municipally sponsored programs. A municipally sponsored program is one in which the municipality works with a nonprofit, and that could be a whole host of different things, but typically it's 100% affordable housing, meaning that all of the units within that development are affordable to low and moderate income households. The municipally sponsored program, I would say, is one in which, in order to build affordable housing, the subsidy has to come from the municipality, whether it's through land donation or whether it's for financial subsidies. That is how affordable housing is built, and that's how a municipality generally meets the constitutional obligation. So the past, New Jersey affordable housing history, it's a long history, and I'm not going to go through it in detail. These are the highlights, however, and what I'd like to do is kind of do pre-2015 and post-2015. Pre-2015, and then second and third rounds, it's the first, second, and third rounds. The first and second round, you're going to hear me talk about rounds. The first and second round were kind of combined together to make the second round. So first round, I won't talk about a lot because it's subsumed within the second round. The third round was also overturned, and so you will hear me say third round twice. One was overturned pre-2015, post-2015 is kind of where we sit today. But in 2015, I'm sorry, in 1975, as I mentioned, Mount Laurel 1 was decided by the Supreme Court. This is the ruling that indicated that every municipality has a constitutional obligation to provide for affordable housing. And that was the landmark decision that we all have started, that we've all abided by, municipalities have abided by. From 1975 to about 1983, I would say majority of municipalities said, great, that's a constitutional obligation. We're supposed to zone for affordable housing. Many did not. And there were some that just did some upzoning and allowed for apartment units to be built, but many kind of just sat and waited to see what would happen. And what happened was it started in about up to leading up to 1983, many builders started to sue municipalities saying, well, you have the obligation to provide affordable housing, but you've done nothing. So they sued several municipalities, and Mount Laurel. What happened was it sat in the courts for a long time, meaning that the builders sat in court, and there were so many of them that it was very difficult to process all of those builders' remedy suits. And a builder's remedy suit basically is something that says, I'm a builder, I have a piece of property, you have not met your constitutional obligation to provide affordable housing. I can do that, I can help you with that, upzone my property, and therefore I will provide for my set aside of affordable housing. So there were many builder's remedy suits that occurred during this period of time, and it became chaos in the courts. So the Mount Laurel 2 ruling was such that there were obligations then assigned to municipalities, and the court started to approve those plans. And the builder's remedy suit was something that they used to do that. In 1988, as we got into the 1986 to 2014, they established something known as the Council on Affordable Housing. This was an administrative body through the state of New Jersey that was meant, instead of the courts, was meant to review your fair share plans, your affordable housing plans, and approve them. And that approval gave you the stamp or the immunity from future builder's remedy suits. So COA had a whole process. They created obligations for municipalities. They created rules that we are to follow, and we still follow most of them today. And that particular process was something that municipalities, a lot of them, went through and spent a lot of time with the Council on Affordable Housing from 1986 to 2014. There is a Mount Laurel 3 that doesn't get a lot of press. In 1988, the COA process was upheld. Actually, this municipality was named in one of the suits. It's a famous suit, Hills versus Bernards Township. But basically, what developers were trying to do was say, you know what, we have a builder's remedy suit. We don't want to go to COA. We want to stay within the court process. And I don't know all the details of it, but for the most part, the Supreme Court said, you know what, this is an administrative process. The Fair Housing Act's been passed. Well, we want everything to go through COA, the Council on Affordable Housing. So that process was kind of upheld through that Mount Laurel 3. It was a long history pre-2015. Towards the end, from probably 2010 to 2014, COA really struggled in adopting third-round rules. They would adopt them. Municipalities would adopt plans that are conforming with them. They'd be overturned. It was almost like the secular thing every couple of years. Municipalities were just on this hamster wheel trying to figure out ways to comply. By 2014, it was clear that the Council on Affordable Housing just couldn't get the job done. And so post-2015, there was a Mount Laurel 4 decision by the Supreme Court. The Fair Share Housing Center, which is a nonprofit agency that really their main goal is to provide for low and moderate income families with housing. So what they did was they brought the suit up to the Supreme Court. They said COA's not doing their job. They didn't adopt their third round rules. Therefore, court, you need to take this over again because it's just not, the job's not getting done at the administrative level. And so in 2015, Mount Laurel 4 was decided. It was a huge decision because what it did was it took all of our fair share plans, our planning processes, and pulled it into litigation. And so we're no longer doing an administrative review process. The court system now takes over all of these cases, all of the towns, and the court will then approve what's known as the third round plans. And so that kind of brings us up to where we are today. That started in 2015. There was a lull about 4 or 5 years because the court was trying to come up with obligations for municipalities. Once we knew what the obligation was, everybody quickly put together plans and got them approved through the court. Some are still dwindling in there and going through that process, but that's essentially where we sit today, and it will be ending in 2025, June of 2025. From 2025 to 2035, that's what's now known as the fourth round. It will be an administrative review, and we'll talk a bit about the fourth round and the Fair Housing Act and the changes that have occurred, but the administrative review will be in the courts. Sort of. So a few affordable housing concepts and terms. I've talked a bit, I've said some of these terms. I wanted to just quickly define them just in case anybody has questions. The Fair Housing Act is the act that creates the rules, the regulations for affordable housing in New Jersey. It was originally adopted in the 80s, and now it was amendment. There were several amendments over the past 30 years, but we've had a major amendment, which is known as the fourth round, or for the fourth round. So that Fair Housing Act is what we look at now as we move into 2025 for guidance as to how we're going to put our plans together. Builder's remedy lawsuit, as I indicated, a builder can come into a municipality if they do not have immunity, meaning they did not provide a fair share plan that has been approved either through COA in the previous 2015 realm or by the courts. A builder's remedy lawsuit basically states that you have exclusionary zoning. It is not inclusionary, and I am the developer that will be able to provide for a portion of your affordable housing, and they basically want a court to approve their plan of upzoning, increasing density on their property in order to provide a set aside of affordable housing. Fair Share Housing Center, as I mentioned, is a nonprofit organization. Their goal is to provide for and speak for low and moderate income families that can't speak for themselves in this process. The obligation rounds, as you see here, the first and second round ran from 1987 to 1999. The third round ran from 1999 to 2025, and now moving into the fourth round next year will be a 10-year term, 2025 to 2035. A fair share plan is that plan of affordable housing. How is a municipality going to put together that plan to meet their obligation? Typically, it's pieced into two parts. One is the new construction obligation, and the second is what's known as the rehab obligation. We don't have to get into the details of that, but the new construction obligation is really the one that we focus on the most because that requires zoning, that requires municipally sponsored programs. Rehab obligation, you have a program already. It's basically as long as you have a program up and running that allows for money to go to the rehabilitation of existing units that house low and moderate income families, you've kind of met that obligation. Inclusionary zoning, as I mentioned, is the ability to have a set aside of affordable housing. So typically you look at 80 to 85% market rate and 15 to 20% as a set aside for affordable housing. That's what's known as inclusionary zoning. Municipally sponsored programs, as I mentioned, is truly typically 100% affordable housing. All the units are affordable, but the municipality has to be the kind of the ability to provide that subsidy, whether it's land or financial resources, in order for that nonprofit to build those units. Family versus age-restricted units. This is important because there is a requirement that there's a minimum number of family units and family rental units that are part of your obligation. So if you get an obligation, you say, great, we have a huge senior population that needs it, let's do all senior units. It's not permitted. So it's important to understand the difference that their age-restricted units have a limit. You can't meet your obligation with all age-restricted units, and family units are basically non-age-restricted units. Special needs housing, this is known as special needs and supportive housing for folks that have mental and behavioral and physical disabilities. And so special needs housing is a huge need in the state of New Jersey, and we'll talk a little bit about that in a second, but there is a special category for special needs housing, and you get special bonus credits for special needs housing. AH, you'll probably see this. I do a lot of the acronym AH. It just means affordable housing. And then a set-aside is essentially setting aside a certain number of units for affordable housing. So that's just some terms that you'll probably hear me talk about now and into the future. So as it relates to the past, the township has had 35 years of compliance. You'll see in the first and second round, there's been several approvals, 1989 and in 2000 through Council on Affordable Housing. You actually had a third round certification. You're one of not many that had a third round certification from COA, and that was in 2010. It was kind of right before COA went a little crazy and nothing really got done. So you did have a certification of third round. Unfortunately, that didn't really mean much because the third round rules were overturned and new rules were adopted, or not new rules, but the court stepped in, and you did have a court approval in 2019, which you're under currently. So you have what's known as a judgment of compliance and repose. And you have immunity. So as long as you've been compliant for the past 35 years, you've had immunity from builder's remedy suits. But I just wanted to give a sense of, this isn't new to the township. This is something that you've all been working on for many, many years. Your third round plan. So your third round plan, as was indicated, was approved in 2019. This gives a little bit of a sense of what is involved in that particular plan. You had a large obligation. It's up there. You're probably the top 20, 25% that I've seen as far as the obligations are concerned. Your rehab obligation was 44 units, and your new construction obligation was 873 units. So it's a big, big number. You were able to do a lot of interesting mechanisms to address that obligation. There were extension of controls, over 200 of them. Basically, what that means is that you had existing affordable housing that their deed restriction, which typically is up in 30 years, was ending, and you were able to renew those deed restrictions. So you were able to use existing housing stock, extend controls on those existing units, and get credit for it, which is a huge benefit, certainly for the town. You were able to use existing housing stock, and not have to build 200 plus units. And if you did inclusionary housing, multiply 200 by 5, and that would typically be what you would have to build to meet the 200 units. You had special needs units, 124 beds, age-restricted units, 24. You had inclusionary family rental projects that gave you 116, and you also had something known as a regional contribution, a surplus from the second round that you were able to provide 187 units. And you also get what's known as paper credits or bonus credits for any rentals. This was in the third round that you received. So a very comprehensive, diverse way of meeting your third round obligation. And then as we talk about today's status, your affordable housing statistics to date, and this is about a month or two old, you have 520 units that are currently occupied. Low and moderate families live in those units. Under construction, you have 63 units, and then anything that's been approved or zoned for is 75 units. So so you've done a really good job in meeting past and third round obligations and folks living in needed housing. So who qualifies for affordable housing, and what is it? This is most up-to-date 2024 income limits. And this basically is a chart that gives you a sense of who can afford affordable housing. And I'll just use the two-person household. And if you follow that column down, it starts with median income. You are in what's known as Region 3. That is Hunterdon, Middlesex, and Somerset counties together. That's important, and I'll tell you why in a second. But if you look at the two-person column, the median income is $116,960. That's what's then used to determine what moderate income is, what low income is, and very low. Moderate income is 80% of median, so you're a family that earns $93,568 or less is considered a moderate income family. A low-income family is considered 50% of median income, and that's $58,000. Anybody that a two-family household that earns $58,480 or less would be considered low income, and then very low is $35,088. So it gives you a sense of who can afford and who would be able to vie for affordable housing. So what does that mean as it relates to home sales prices and affordable rents? This is illustrative. This is not me telling you this is exactly what it would be, but I wanted to give you a sense, a range of what we're dealing with when we talk about what's affordable, both on the sales side and the rental side. So if you look at a two-bedroom house that's affordable, it would range anywhere between $175,000 to $203,000. And it depends on really, are you low income or moderate income? The range that you see there is between low and moderate. While there's a very low income category, most folks that sit in the very low income category can't get a mortgage for sales products. So typically we look at low and moderate. So that gives you a sense of what things cost. Your rents, let's look at a two-bedroom. That would run from $735 a month for a two-bedroom to a very low household to $1,675 a month for a moderate income household. So just wanted to give you all a sense of kind of what are we talking about when we look at affordable housing. And just want to mention here, when it comes to affordable housing and how you get affordable housing, meaning if I have incomes that sit in that range, how do I vie for affordable housing? There's an application process, there's an income qualification process. Somebody looks at all of your data and then basically indicates that you meet those income levels and can put an application in for affordable housing. That's all based upon something known as affirmative marketing. So there has to be a marketing throughout all of those counties. So the region gets the marketing for any development that would come up, and folks come from all those counties and can put their applications in for rental properties or for sale properties. There is not a residency preference. I get that question a lot. So that is not something that is considered to be legal in the affirmative marketing world. And I'll be able to answer any other questions as to the specifics of how people qualify. So the future. So it's a lot that we've gone through the past and the present. We are now moving into what's known as the fourth round of affordable housing. It runs from June of 2025 to 2035, and the Fair Housing Act, the law, has been updated and amended and signed by the governor in March. And this law provides for some basic regulations, some basic ways in which you as a municipality and the municipalities across the state have to comply and show that you are in compliance. And we will be following this law as we start to plan for the fourth round in the township. It is now what's known as a court administrative process versus litigation. As you remember, you may have remembered, I said that the third round was in Superior Court. It was through a litigation process, litigation mode. They have the Fair Housing Act has pulled that away and basically has said it will now be a panel of judges that will be part of it's known as the program, and the program will review all of the municipalities. Anybody that submits their plan will review them in accordance with Mount Laurel Doctrine and the Fair Housing Act. I would anticipate that we may have rules that come out similar to the rules we've been filing in the past 30 years with Council on Affordable Housing. We will see what happens. We will have a fair share plan that needs to be adopted, submitted to the program by June 30th next year. So right around this time next year, it will be completed and most likely being ready to be submitted for review. General requirements of our next fair share plan or our next affordable housing plan. First is we have to look at our third round, and is there anything missing? Has somebody not built? Did somebody go defunct? Are we missing credits? As we can tell right now, I don't think we're in that posture. I think all of our third round credits are pretty solid. we must look at redevelopment opportunities. This is part of the law. There is definitely a focus on redevelopment versus sprawl development. Where are there places where there's maybe vacancies occurring in existing commercial, industrial properties that we could provide for redevelopment of those properties? The law does require us to kind of take a look at that. These are the minimum requirements that I kind of talked about when I said the difference between family and age restricted. So with the obligation, and right now we don't have an actual number for the fourth round quite yet. Our office is working on it, putting together numbers based upon the methodology that was put out in the Fair Housing Act. The DCA, the Department of Community Affairs, has to provide a number by the end of I think it's by October, and we have to adopt it by January. We will have a solid number in a couple of months. But right now, we don't know exactly what that is. We have, I think, a range, but it's something that's still being worked on. However, that obligation, 50% of that obligation has to be for family housing. Of that, 25% has to be for rental housing. So you still have to meet a minimum requirement for family housing. There has to be a requirement for 25% of the obligation to be rental units. And we can't go over 30% of senior units or age-restricted units. So just to give you this is just a snippet of what's in the Fair Housing Act, but wanted to give a sense of kind of what we're looking at as we start to think about planning for affordable housing in the fourth round. They have revised bonus credits, and so you start to get a sense of how they're looking at affordable housing. And when I say they, I meant the legislature and the governor, as to what's needed and what's important. So when I look at this list, you get bonus credits for certain things. You get a full bonus credit. In the third round, it used to be you get bonus credits 1 for 1. Every one rental family unit, every rental unit, you get 1 bonus credit. That's no longer the case. You get full bonus credit for supportive and special needs housing. What's nice about supportive and special needs housing is that you actually get credits per bedroom. So if you have a 4-bedroom home, you get 4 credits for that particular home versus if you would only get 1 credit, like for instance with an inclusionary housing development for one single family house. So for that same single family house, you get 4 credits and you potentially get 4 bonus credits. So for one 4-bedroom house, you could potentially get 8 credits, which is a huge bang for your buck, I think. But also just to me, it signifies that the legislature is concerned about our population of supportive and special needs. The other full credit you get is for any 100% affordable housing project. So any project that the municipality helps with, meaning whether it's land or financial subsidies, and all of the units within that development, and it's done typically by a nonprofit, are affordable. You get a bonus credit for each of those units. And then market to affordable, what that basically, it was also called buy down program. Imagine taking an existing market rate house, $500,000, and a subsidy would come from the municipality to buy it down to an affordable level. That's what market to affordable is. You get a full bonus credit for doing that. It's expensive, obviously, because we know that housing prices are expensive, and so it's not used often. It's usually used, kind of an infill type of situation where you have 3 or 4 credits, and you really need to figure out how to do it. And market to affordable would be potentially one way. So you get full credits, full bonus credits for those types of projects. You get half bonus credits for all the ones that you see underneath there. My view of this is that they again are focusing on locations of affordable housing near transit, which to me means in my mind, it's smart growth. You want folks to be able to take advantage of existing transit, which this township has a plethora of opportunities. So they're providing half credits for any units that would come close within a half mile of transit. Redevelopment, as I indicated, of any commercial space or industrial space, they're giving half credit for that. And then you can kind of see the other ones that are there. There is a requirement, there are requirements that there are a minimum number of 3 bedrooms in any project and a minimum number of very low income very low income units in projects. If you go above and beyond that, you get half credits for that as well. So So what's happening in the future? We are currently starting the planning process, going through strategies, looking at the Fair Housing Act, figuring out what makes most sense, not only for the needs of the municipality. I think a couple things. For the needs of the municipality, how do we reduce suburban sprawl? How do we protect the character of the municipality? And some of the things that we want to do, obviously, is maximize bonus credits. Make sure that we maximize as many bonus credits as we can, up to 25% of your obligation. We want to maximize special needs housing. We think that's important. And we want to maximize senior housing. All of those areas that we see a need occurring, but also try to do it in such a way that it's, it reduces the land area that it would take to meet that obligation. So that's really what we're starting to do. There have been several projects that have been introduced and submitted to the municipality, to the governing body for review. And so we are looking through and starting to consider many of those projects and what are the pros and cons, and how do they maximize bonus credits, and our overall planning strategy, which really is how do we make sure that it's infill housing, use existing housing stock where possible, and then be able to, I said, maximize our credits. So that's really our next step. At this point, there's a subcommittee. We're meeting on a regular basis, and we're kind of working through proposals and how they're meeting these goals and objectives. The next steps would be, I would anticipate that sometime after January, there would most likely be some public input sessions at the planning board when we start putting a draft plan together for input from the public as well as from the planning board, and receive comments and be able to kind of take a look and feel what the public is saying about this plan. The one, and I know this law has gotten a lot of bad press. And I think the one thing that I find good about it is that it allows for the planning process to be at the planning board again. Previous to this, it's been in litigation mode, and it was really kind of behind closed doors, and it was really a negotiation process. Now, being an administrative process, I feel better as a planner that it's where it's supposed to be. The master planning process and the housing element and fair share plan are supposed to be in front of the public for the public review and for planning board to review it, as well as governing body to endorse it. So given all of the bad press, I feel like that's at least one shining star in the legislation. So with that, hopefully I covered most of the items, but I'd be happy to answer any questions anybody has. Yes, ma'am.
From what I've read, that immunity is not, we don't have immunity all the way through. We have to pass some gates, and if you don't, municipality does not pass whatever they need to pass and approve it, you lose your immunity, and then you don't get it back until you do it. What you would feel the impact of that is?
So the question was about immunity and the different times in the as we go into the fourth round. When will that occur if we don't hit certain steps? The first is in January of 2025. We, as a municipality, are to adopt your obligation that will come from the DCA, or it can come internally as well. But you will pass a resolution saying this is what we believe our obligation is. If you don't do that, you potentially lose immunity. The second gate of losing immunity is if you don't submit your plan by June 30th of 2025, you will potentially lose immunity. So yes, there are roadblocks that are in this law that really create, it's an aggressive timeline. Don't get me wrong. Not only for us putting together, for planners putting together and towns putting together the plans, but once they're submitted, somebody has to review them within a very short period of time. And there's objections that are allowed during that period of time as well. People can, object to your plan, but it's an aggressive timeline.
You're talking about immunity from builder's risk.
Correct. Yes. Thank you. The immunity basically means that you are immune from somebody coming through the court and saying you are exclusionary zoning. I think one of the criticisms of the law is that all of this is still happening while you still have you should have third round immunity up until June 30th, 2025. So there, it feels like you've done everything you're supposed to do. You should have immunity till that period of time, but now, they creeped back into the third round and potentially create another roadblock that said, regardless of what all the things that you did, if you don't adopt this resolution, agreeing to an obligation, then potentially you lose immunity. So yeah, that's. Any other? Yes, ma'am. Yes, sir.
On that special needs housing thing, how does that usually happen? Is that like a corporation or a nonprofit comes in, buys a house and says we're going to set up a special needs house?
Yeah. So the question is, how does special needs housing occur? It's done in a couple of different ways. That would be the typical process where a nonprofit, an organization that deals with a particular disability, finds a house and they retrofit it for their needs, for separate bedrooms, and they typically will go to municipality and either say, "We bought a house, we need help with renovating it. So could you help us out with that?" Because you'd get credit for it. The other way it's done is municipality may have property, may be able to help with building a house. But yeah, it's typically nonprofits, folks that own and operate for a particular disability. Yes, ma'am.
Why are we so scared of overdevelopment? It seems to me that if more houses get built, will they become cheaper over time, especially a housing crisis? Do we want to build as many houses?
It's an excellent question, and I think that so the question was, why are we scared of overdevelopment? I think really the question is, can we provide the obligation in a smart way? And it's called smart growth. And so, for instance, rather than having farmland, a huge piece of farmland where you have, let's say, acre size units, maybe you have something that are smaller units, smaller size acreage next to a train station. So you don't necessarily, you could still meet 50 units, the 50 units that we built in the farmland. Those 50 units could be consolidated and clustered close to a train station. So I don't think it's necessarily a case of overdevelopment. I think it's developing in such a way that it's smart and it meets the needs of the municipality. You have 2 train stations here. Those are, while most of that area seems to be built out, I think there's opportunities for redevelopment to occur. But I think the idea is that when you have affordable housing and when you have inclusionary housing, folks that, especially very low income households, and this is hard to believe for some people, may or may not have a car. And so making sure that we put those communities close to retail, close to schools, close to parks, that they can just bike or walk there, that's a really good planning strategy in order to do that. So I don't think it's necessarily overdevelopment, but I think it's more smart growth development. Yes, sir.
When people apply for, is it based on the township, or does it go through the legislature? When you apply for the lottery or whatever, is that just through the township, or is that through the county, or is that through the state itself?
So the question was, how do you apply for affordable housing? The process is that you would actually go through the township. The township has what's known as an administrative agent. And if you go to the township website and you look, I think there's a affordable housing link. You go there, there's the administrative agent that takes applications in for certain communities. There are other communities that the developer would potentially run, so you could apply to them as well, but it is definitely more local for the area that you're going to be applying.
Our township's going to be cracking down more on people's information. I work for a home builder, I build affordable housing, and there's people that live it all the time. Like my last development in Bergen County, I had one guy that he was a doctor for 50 years, a millionaire, had a lot saved up, and what they do is they transfer their money to their kids' account, so it looks like they have nothing, and then they afford it, which they don't need. Like, and he pulled out a brand new Porsche that he just bought from money that was in his kids' account now. And there were multiple people that did the same thing. So is it, are townships going to be cracking down more on it to find out?
Yeah, so the question is, how does an administrative agent ensure that the person that's applying for affordable housing is truly in need of low and moderate income housing? There are guidelines that the state puts forth on the administrative agents and the townships. It's the Uniform Housing UHAC, Uniform Housing Affordability Controls. Those regulations and those state law, they mandate what an administrative agent has to do when they're looking at a person's income. So I don't know what happened in the case that you were talking about, but there's very stringent ways in which they're to go through the qualifications of low and moderate income families. Yes, ma'am.
Are there any different provisions to control the density for affordable housing, near the transit station?
As far,
Not just affordable housing, but, I mean, apparently the market value of houses near a transit would be more than, let's say, further from there. So how are there provisions to control the density if we were to increase the number of affordable?
of units. So the question is, how do you control density in locations like transit that would potentially be more valuable and people would want to see higher density? I mean, that's municipalities. That's completely under the control of the municipality from a zoning perspective. I would say transit areas, I mean, there's differences between the middle of Jersey City and, an hour away from Manhattan, for sure, as far as densities are concerned. And so we have precedent densities in transit villages that are similar to this area. We'd probably look to that, but I really think it has to do with the location, the characteristics of the location, what's surrounding it. I mean, if there isn't necessarily a huge transition between the transit village or the transit area and then single-family homes at an acre, adjacent to it, we'd be very cognizant of that as we start to create densities. So I think that, and a part of it is not only, from the municipality, the planning board, and the governing body, but from the public. The idea of us being in front of the planning board and getting a housing plan approved by them, they're the entity that approves it, the governing body endorses it, is that we do have public input. And, does this make sense? And those questions that you're asking would be very appropriate for that. Yes, sir.
If I understood the numbers correctly, that the obligation hasn't changed from the original 917.
It has. There's a new fourth round obligation. It won't be as high as the third round obligation. The third round obligation was a period of almost 28 years, I think it was. This is just a 10-year obligation. So I would assume that you're probably maybe half of that, maybe a little bit more than half of that.
Even though we've got 650 out of 917, so that's all in flux because of new changes.
Yeah, so the existing third round obligation you've met. You've created the zoning, you have done all the things you needed to do. So it's almost like an ending point. The fourth round obligation will be a brand new number, and so you'll have a brand new plan to meet that obligation. Correct, yes. You have a whole new number for fourth round, yes. Any other questions?
Yeah, I have a
Oh.
question. There are two items that are like hot button right now, accessory dwelling units and sober living facilities. Are sober living facilities considered special needs going into fourth round?
So the question is, are sober living facilities considered special needs? Typically not. They're considered transitional housing. You now get credit for transitional housing up to 10% of your obligation. So, folks that are going through homelessness and they have a transitional housing before they go to permanent housing, that could potentially get credit. What was the other question before? ADUs. Oh, ADUs, accessory dwelling units. They're also known as accessory apartments. You've always had the opportunity to get credit for that. I'd say it's more difficult because accessory dwelling units, as you all know, yes, it is something that is of interest, that people can put them on their property. The affirmative marketing process makes it really difficult or challenging to do that, because most people on their single family lot and they're building an accessory dwelling unit, typically it's for a family member, mom who wants to move back or needs a place close to the family, or your college students coming home, or whoever. You can't do that with an accessory dwelling unit in order to get credit for it. It has to go through the affirmative marketing process. So while it's out there and it's an opportunity, most folks and municipalities don't take advantage of it just because of the rules around it. Yes, ma'am.
So my question is, do you have any insight into how they're going to come up with the number?
There's a methodology, so the question was, how do you come up with the obligation? The Fair Housing Act has a methodology. It's based upon what's known as the Jacobs decision, which was Judge Jacobs decided on a methodology in the third round. Most of that methodology has been kind of plopped in the Fair Housing Act. And we as planners are starting to kind of walk through that and figure out how to get to an obligation. There are, I would say that it's not as cut and dry as I think the legislature thinks it is. But what will happen is, in my opinion, is we'll come up with your number. We'll wait for DCA to come out with their number, see if it matches. If it's off, we'll take a look at it. But what we want to do as a planning firm is to ensure that any judgments that we make on some of the methodology they're solidly based, and so we want to be able to defend it even if doesn't meet the DCA. The DCA comes out with an obligation, but you're not obligated to accept that particular obligation. So if it's something that's a little bit less and we can defend it, then that's what we would do.
Negotiation between October and January, potentially.
Correct, yeah. I think between October and January, we're going to have some discussions about, okay, yes, that meets exactly what we thought, or it's off a little bit, and let's go back and take a look, and are we really confident in what the obligation is? I have a feeling it's not going to be a huge divide between what most planners come up with and what DCA comes up with.
So just some highlights of, like, is it what goes into, like, our population, what space buildable space, or where we're at?
Part of it, there's a land factor. They look at what I would call developable land, and it's not necessarily so focused on a municipality. It becomes more, the obligation is allocated, it put on a region, and then you allocate it to municipalities within that region. And so land factors are part of it. What building permits have been issued, what low and moderate income family, low and mod have already been built, and so it's.
Transit stations you might or might not.
No, that doesn't necessarily go into it. It's really developable land. What is the developable land? And then you as a municipality say, okay, this is our obligation. Makes sense that it goes here, here, or here. So, yes, sir.
Depending on the builder, townships have control of what they go for. Is that all based on the builder? Like, say the development Duke Meadow just got built, are they dictating what the rents are? Does the township step in and have a little control?
So the question is, how does a builder make sure that they're building affordable housing in compliance?
In compliance, but like, they're not like overpricing.
Right.
Does the township have a little bit of say in that?
Absolutely. So the builder will most likely have their own administrative agent that has to income qualify, has to do the affirmative marketing in accordance with what I had said before, the UHAC rules. But the municipality's administrative agent actually has to oversee that as well. So the data coming from the builder comes to the municipality for review by the municipality's administrative agent.
You know, 'cause the development I'm working on right now down in Monmouth County, they're doing that, but at the same time, like, from what I've seen for the last 6 years doing this, even pre-COVID, it's not making housing more affordable, it's raising it up. Because the problem is with low income units, it's raising with the regulars, which is not making it more affordable.
So as far as the question was about income and not income, but rents and sales prices. So each year, and I think I showed you that slide, each year those income levels do go up as far as who can afford affordable housing or who can qualify, but also the amount of rents and the sales prices go up each year as well. So for instance, this past from 2023 to 2024, for this region, I believe it went up 5% for sales. You can increase the affordable housing by 5%, and I think it was maybe 2 or 3% for rentals. So there's a guideline. They have to stick by a certain guideline. They can't do exorbitant amounts of increases in rents. There was a question. Yes, sir.
Just to follow up to the question this lady over here raised, the most important thing, I think, for a lot of us initially is, what's the total number? Now, I waded through some of those long reports that were issued back some years ago. You mentioned Jacobs, I don't remember the exact name. And I was quite surprised to find that in determining the quantity of affordable units, the analysis started with something that goes back to the 70s or more, that a person or a household should not spend more than 30% of their household income on housing, okay? And if you work through that to the numbers that were allocated in 5 years ago, excuse me, it turns out that 40% thereabouts of households in New Jersey were judged to be in need of help, which strikes me as an unusual number for a state like New Jersey, that we're saying that we've got to provide affordable housing for 40% of the households. Now, do you agree with that as a starting premise? The resulting number was 40% of all households, starting with the idea that you shouldn't spend more than 30% of your income on housing.
Yeah, I mean, so the question was, do I agree with 40% so 40% of the New Jersey population shouldn't spend more than 30% of their income on housing? I think that was right. So, I mean, I don't know the statistics. I honestly don't know the answer to your question. I know that we have a housing crisis. I know that there's a need for low and moderate income housing, but I also know there's a need for kind of what's known as the middle missing. Folks that maybe they earn median income, but they still can't afford housing in the state of New Jersey. And so I'm not sure what the 40% alludes to, but I know that there is an essential need, and I'll get on my soapbox a little bit here. That's where I think ADUs do come in and help with that kind of middle missing. I think that's where duplexes and triplexes and quads come in to help with the middle missing. The folks that don't quite qualify for moderate income, but they can't necessarily hit the market and afford a market. So. One of the things that I've always seen with this housing law is that we do give so many credits for low and moderate housing, income housing, which I totally agree with. I wouldn't be doing this. I feel very strongly that we need to do this in the state of New Jersey. But at the same time, I think we missed the boat. A lot of states are now going through allowing for ADUs and just allowing them, and you don't get credit for them, but they're necessary in order to meet a certain need, which I don't think the state necessarily recognizes quite yet.
I'd like to follow up on that. I think there's room for public discussion as to whether in the state of New Jersey there should be help for 40% of households. That strikes me as a big number for a state like New Jersey. Now, I don't deny that we need affordable housing. So the next question is, we used to have a state master plan and master plans at the local level that are all, do we have anything like that now?
So the question is, we used to have a state plan, and the municipalities would have to be what's known as cross-acceptance, being somewhat compliance with that state plan. We haven't had an active state plan since 2000. So we are actually currently in the process. The state is going through the cross-acceptance process. They are going through and hopefully adopting a state plan. I don't know if it will or will not happen, but that's happening through your county. The counties are taking all the municipalities and taking a look at maps and sending information back to the state. So that process is currently in the works.
So if that is completed, then there will be a ceiling on the amount of households in New Jersey.
I don't know about that. I don't think there's going to be a ceiling of households. There's never going to be a moratorium of development in the state of New Jersey.
Okay. Now, the next question, which is important, is once you have this overall requirement, and I gather that our requirement will be part of a 3-county requirement, not you had so-called. But anyway, once there's an overall requirement, the question is, how do you divvy it up? Now, the analysis that I read 5 years ago had a very strange way to divvy it up. They didn't give us credit for developed property. They didn't give us any recognition of something like Lord Starling Park. It was just that somebody took a number for the amount of acres in the county or in the municipality and simply said, okay, you get that much, without any consideration of what's already happened.
Yep.
Is the present law going to be administered that way?
So the question is about does the obligation, does the methodology take into consideration existing constraints on development, meaning, really looking at what's developable versus not. And in my opinion, it does. There's a land factor that goes into the obligation, and I feel like the methodology does take into account to some degree that, not completely, but it does take into account some.
I haven't read the law.
Any other questions? Yes, ma'am.
Could you describe the affirmative marketing process?
Sure. So what happens is, let's assume a developer is ready to either release a rental unit or release a for sale unit. And let's assume that the administrative agent is employed by the town. That particular administrative agent would also have to be employed by the developer. They go under contract. The administrative agent then helps with putting the affirmative marketing out there. So it would go to, and it's in accordance, you have an affirmative marketing plan that's been approved. So it's in accordance with your affirmative marketing plan as to what radio stations, what newspapers it goes to, where it gets placed on. It would most likely get placed here, it would get placed on your website, it would get placed on the developer's website, so that, and it goes throughout those 3 regions. So it goes to county, libraries, employers, so your affirmative marketing plan says all of that. There is a application process that it typically allows for 90 days for folks to apply. Those people going in to apply basically say, here's what my income is, please consider me. And they'll go into a list, a wait list. And what will happen is that wait list will be randomized. So it's not first come, first served necessarily. There's a randomization at that 90 days. Once that randomization of the names comes through, number 1 says, I would like to have a 2-bedroom moderate income unit. There's one available. They go through what's now known as the true income qualification process. So they look at income, bank statements. That it's a rigorous process. And if they meet the qualifications, they get a notice to say they meet it, and then they can go look at the unit. And then they kind of work down through that wait list. That's a general sense. It's a bit more complicated. Yes, ma'am.
In my experience, it seems like the people that make out the most in this process are the developers. And they're given things like pilots, and they're giving an opportunity to sue to meet, in order to help you meet your affordable housing plan. And they typically only have to offer 15 to 20%, as you well said. So is there any pushback or anything that happened with this law to make it less, to make the developers bear as much of the brunt of the pain that everyone has to feel, versus them just walking away with money in their pocket?
So the question is, how does this law impact developers? Meaning, is there any requirement that makes them have a higher set aside of affordable housing? Nothing in the law requires that. Actually, the 15 to 20% has always been more of a guidance number, and it's based upon return of income. Return of profit, return of investment. That very smart financial people have run pro formas and realized that. Typically, it's through negotiation. So, for instance, you have a developer that comes in. Maybe you really like the project, but you need a higher set aside. You ask for it, and in my negotiations and my conversations with developers is show us the money, show us the pro forma, show us why you can't provide additional set asides. And I think it's every right of a municipality that's going to work with a developer to ask that question. Yes, ma'am.
Regarding like the developments of, large housing, multiple housing, does the municipality have input into that sort of architectural guidelines or anything like that? Or is it, you just have to go with, you have certain guidelines and it's just based on the number of units? Or does the town have input into, sort of, like.
What it looks like. Yeah. So the question was, how much does the town have, I guess, the ability to review and provide guidance on architectural as well as site layout? I think the township has a lot. of guidance in that regard. When you are working with a developer and you're coming up with zoning for that property, you're basically rezoning the property to allow for a development to occur. So in that rezoning, while I said we're an administrative review process, that's true, but there's always negotiation with developers. So for instance, you're going to talk about what's the architecture, what does it look like, what's the site layout, how do people circulate in and out, how does it impact the roadway system? And so that conversation absolutely occurs, because what you're doing is creating zoning for them, and in that zoning, you're going to put those rules and regulations in there. Any other questions? I think we're good. Thank you all.
Before I have closing remarks, I would be remiss if I didn't ask our Assemblywoman, would you like to make any comments? Since this is a state topic and your expertise, perhaps? I'm just completely putting you on the spot.
She's used to it, right? Yeah, I'm used to it. Thank you, Jen. I would say you certainly have given us a very thorough presentation. I appreciate that. I also would agree with your statement, and I wrote it down, that this was an extraordinarily aggressive plan that was pushed through without very little public discourse. And the legislature was really, we had very little input. I did not vote for it. Because of the lack of transparency and the way that they presented it. That's just full disclosure. I'm a lot concerned. We have 564 municipalities in the state of New Jersey, and these numbers are being imposed on everyone. The young lady in the back asked the question about what is the problem with overdevelopment. It wasn't the way she put it, with housing. And the problem is that we have an aging infrastructure system in the state of New Jersey. We have massive flooding in the state of New Jersey. I'm the budget officer for the Assembly on my side of the aisle, and when I asked the Commissioner of DEP, will you admit that there's an issue? They're looking at two different silos of development and our flooding issue, and the answer is that they're completely separate issues, and they're not looking at that as a one topic issue. I represent 19 towns, one of which is Westfield. Westfield they closed a nursery, which is all permeable land, and they're putting up 169 units in an area that currently floods when it was a nursery. So the issue is, that I see, is it overdevelopment in the sense of how it affects the infrastructure. Berkeley Heights is in my district. They have an inadequate sewer system currently before the building starts. It's because we're a very old state. Other parts of the country have newer development. We're old sewer systems, old infrastructure. It also puts a strain on the school system. So we have to acknowledge that. We have to employ more. You have to employ more employees. So yes. Again, it was put through in an aggressive plan, and the builders come out ahead in many cases on this. And so, but I just want to say that I appreciate your thoughtful analysis and your thoughtful presentation. I think it was really good. I think that you're fortunate that you have the people here who can ask you the questions, because I think that there's a lot of issues. Every town is dealing with this, and we're in a very tough spot in the state. And again, there's a sense that we should have slowed this process down, taken a better look at it, because what we don't want to have to do is what we're doing, which is adjusting legislation as we go forward. We pass a bill, we make it into law, and then we have to make amendments, and that's an issue. We do it over and over and over again. And in my view, things that go through really, really, really quickly sometimes are the worst pieces of legislation, because we don't take the time to do the full analysis. So, but that being said, I really, truly appreciate both Andrew McNally and Jen Acey and your current counsel, Janice Fields, for working with you, who certainly has it handle on, I'm sorry. Yeah. Yes, I'm sorry. Yeah, I knew I read, you know what? It's like, yeah, no, I just understood, for handling this, because you're going to have to handle it. But again, that's, as a legislature, this was, rushed through in lame duck, I believe, without thoughtful analysis. Whenever things happen that way, we're going to encounter problems. So I give you guys credit for letting the public know what's going on. And again, it's going on, and you have more land here than many of our towns. You know, Summit, I live in Summit, Summit is pretty built up. Short Hills is very built up, and they are, you know, these numbers are being imposed. Fair Share Housing is imposing these numbers, and they are being told that that's the number you have to build, you know, and they are not sharing the formula with us either. We're the legislature. They are not sharing the formula of how they come up with these numbers. So credit to your governing body for doing the hard work, for including all of you in the discussion, you know, and those are my comments.
So a few other comments. You know, when this legislation just really sort of magically and very rapid fire was put in place, the subcommittee was formed quite quickly. We did not intend that this needed to be a topic this year, but it was because that the legislature changed the law. And so the subcommittee had to form very quickly. So Gary Bauman, from a township committee perspective, and myself are representing the TC on that. And Mr. Bellardo, who is here in his private capacity, he's our township attorney. We said we need the best, and we want the best before the law's even finished. And so we're very grateful that we have Kendra and also Beth. And so I feel very confident. I hope that you feel confident in her expertise as we guide through this morass, as we're going to try to do, right, what the state imposes on us, and to do it in a way that maintains the character of our community, as well as protect the environment. And that's one of the things that, for me, I worry about with development, just a simple thing, right? You pave over. Well, are we having flooding problems? Yeah. So let's not put more development in, but we're going to have to. So it's one of those things of really protecting the environment. So again, thank you, Mr. Bellardo, for helping us to hire what we think is the best. And the subcommittee, she mentioned some of the subcommittee work. We are turning over every single rock. Any idea that meets as what she required, building as few as possible, right? What can we do as creative as possible? That will be something that we're considering. I also just wanted to mention that we were proactive. So we did not wait until the law was signed. We took action in January, first meeting in February, and have been meeting regularly since. So we are in the information gathering mode. There are no decisions that are made, but you heard that we're going to be told a number in October. We're not waiting for that number. We're going to have the investigation and information gathering, and we're going to try and figure out scenario planning. And as much as we can be as transparent with you as possible, we will. So, but there is a balance, right? From a public meeting perspective, everyone is invited, including developers. So it's one of those things of being able to maintain transparency in a way that doesn't harm the municipality. So please know that that is the intention, and that's why this meeting has been held, and this is why it's recorded and will be posted on our website. But most importantly, please know that we all are members of the same community. We all know how important it is to us. We know the needs of our community. We know we have senior housing needs. We know we have a large population, especially of autistic children that need a home to live in. Their parents still live here. So at the end of the day, whatever we put together, I can just tell you ethically, I'm going to be able to sleep at night because we're going to do our best to make sure it's what our community needs, that will help to meet what the state requires, but it's what our community actually needs. So with that, I have nothing else to say but a huge thank you for investing your time and effort into listening and to learning, especially our younger folks. This is a normal topic that perhaps you might want to jump into, so I'm impressed. And please share this. Please share this information with your neighbors, those that didn't come. Tell them on the website. I do check to see on YouTube what's the most popular number. So I don't know, is this going to eclipse our tax presentation? So when people want to know how their taxes are developed? So I don't know, it'd be fun to get a little competition. So with that, again, thank you, our council folks, for being here this evening, Assemblywoman, and all of you. Thank you. Have a good night.